is a good one, albeit not a perfect one. At the brunch before graduation, Lindsey Graham also spoke, and he mentioned that our system, though flawed, had a reputation for producing great judges, and I think that's a good description of it. The way judges are selected is closely tied to judicial impartiality. Now, of course, everyone would agree that we want judges to be impartial and free from any personal stake in the cases to which they are assigned. However, if judges are subject to regular public election, they arguably do have a personal stake in the outcome of their decisions, at least in cases which generate public interest. Self-preservation is a very strong motivator, perhaps the strongest force known to mankind. And elected judges cannot help but be painfully aware that if the public is not satisfied with the outcome of a particular case, that dissatisfaction could hurt their chances of re-election. A former California Supreme Court justice once said that ignoring the political consequences of highly publicized court proceedings is like ignoring a crocodile in your bathtub. Our founding fathers were extremely concerned about having an independent and impartial judiciary. I don't think it's fair to say they were concerned about having a diverse judiciary. When they said we the people, they weren't talking about me and they weren't talking about Chip Finney. But they were very interested in having an independent and impartial judiciary. In fact, their distrust of a partisan judiciary was so strong that they included a negative reference to King George III's judges in the Declaration of Independence. That provision stated, King George has made judges dependent on his will alone for the tenure of their offices and the amount and payment of their salaries. And that very basis was used as a reason for the Declaration of Independence. Now, when our country was founded, only Vermont, before it became a state, selected any of its judges by election. In fact, the first 29 states of the Union adopted methods for selecting judges that did not involve popular elections. However, starting with Georgia in 1812, states began to provide for the public election of judges. From the 1830s until the 1850s, Jacksonian democracy brought about a movement toward greater popular control of public office, and this accelerated the trend toward the popular election of judges. By the time of the Civil War, the great majority of states elected their judges, and most of these elections were partisan in nature. As you might imagine, problems developed with a system whereby judicial candidates campaigned and expressed their opinion on disputed issues in an effort to win their party's nomination. Largely because of the increasing incompetence and corruption of elected judiciaries, criticism of partisan judicial elections began to surface at the beginning of the 20th century. In 1906, Roscoe Pound gave a speech to the American Bar Association wherein he claimed that compelling judges to become politicians is destroying the very fabric of our judicial system and eroding the public's traditional respect for the bench. In response to the concern about partisan judicial elections, some states adopted a modified system of judicial selection based on merit instead of politics that became known as the Missouri Plan, because Missouri was the first state to implement it. Under the Missouri Plan, judges are appointed by a high elected official, generally from a list of nominees put together by a nonpartisan nominating commission. Those judges subsequently stand for unopposed retention elections, in which voters are asked whether the judges should be recalled. This system obviously reduces the threat to judicial impartiality occasioned by popular elections. 24 states currently use some form of the Missouri Plan to select their state court judges. Despite the appeal and success of the Missouri Plan, a majority of states still use popular elections to select some or all of their appellate and/or general jurisdiction trial court judges. In many of these states, The process of electing judges is a partisan one, involving raising substantial war chests in order to win a seat on the judiciary. In her concurring opinion in the 2002 case of White versus the Republican Party of Minnesota, Justice Sandra Day O'Connor expressed concern that the very practice of electing judges undermines the goal of an impartial judiciary. She questioned the propriety of judicial candidates raising substantial sums of money in order to be public servants. Justice O'Connor noted that in 2000, the 13 candidates in a partisan election for 5 seats on the Alabama Supreme Court spent an average of $1 million each on their campaigns. One candidate for the Pennsylvania Supreme Court raised almost $2 million in campaign funds, and $2.7 million was spent on the race for the Chief Justice of the Ohio Supreme Court. As Justice O'Connor pointed out, unless the pool of judicial candidates is limited to those wealthy enough to independently fund their campaigns, a limitation unrelated to judicial skill, the cost of campaigning requires judicial candidates to engage in fundraising. Perhaps most disturbing is that in Texas, 40% of the $9.2 million in contributions raised by 7 of the 9 Supreme Court justices for their 1994 and 1996 election came from parties and lawyers with cases before the court. Another horror story about judicial election comes to us from Wisconsin, where this past April, a popular election was held for one of its Supreme Court seats. The incumbent was Justice David Prosser, who faced a challenge from Wisconsin Assistant Attorney General Joanne Kloppenburg. Lurking in the background of this race, or arguably sitting right smack in the middle of it, was Wisconsin Governor Scott Walker's bill restricting collective bargain rights for public employees, a bill which, if passed, would surely reach the state Supreme Court. Because Justice Prosser was allegedly closely tied to Governor Walker, the election was widely regarded as a referendum on Walker's administration, as opposed to a campaign to determine who would be the better person to uphold the rule of law. Due to the national attention garnered by the labor bill, outside interests became heavily involved in the process. And in addition to the funds expended by the candidates themselves, these special interest groups spent a total of $3.5 million on the race. In the end, Justice Prosser was declared the winner by a small margin, which led to a recount at taxpayers' expense, which, as of last Friday, totaled nearly $250,000 and was still climbing. I believe that the picture of the judge as a fundraiser and a political actor is at odds with the concept of a judge being an impartial arbiter of the cases which come before him or her. Although the goddess of justice may be blind, judges who raise substantial sums of money to gain judicial office are not blind to the identity of their contributors. It might be said that they wear blinders instead of being blind. Fortunately, this fundamental tension between the ideal character of the judicial office and the real world of electoral politics is not something we have here in South Carolina, because we do not publicly elect the majority of our judges in this state. Because of that, we don't have to worry nearly so much about crocodiles in our bathtub. South Carolina is one of only 2 states, the other being Virginia, in which the popularly elected legislature elects its judges. If you meet the standards for qualification for a judicial position by being an attorney and practicing the requisite number of years, you need not worry about raising a campaign war chest. Instead, you file an application with the South Carolina Judicial Merit Selection Commission and begin the work of acquainting the members of the General Assembly with your candidacy. Although we do not utilize the Missouri plan, whereby a bipartisan nominating commission recommends candidates to the governor or another high state official who then makes the final selection, our Judicial Merit Selection Commission is both bipartisan and somewhat diverse in terms of membership. It's certainly diverse in terms of racial membership. As Constance pointed out, when you only have 1 out of 10 members who is a woman, it does call into question the diversity in that regard. But there are several layers of merit-based review to which judicial candidates are subjected, including a citizens group and a committee of the South Carolina Bar. There's also a written test that must be taken. I've had to take a written test almost every time I've run, and I've been a judge for 25 years. There's also a public hearing where the candidate is placed under oath to answer questions by members of the Judicial Merit Selection Commission. So even though the general public does not elect our judges here in South Carolina, it does have input into the process, not only via the citizens groups committee, which investigates any allegations of misconduct or poor judicial temperament, but also through the ability to file complaints against judicial candidates and even testify at the public hearing before the Judicial Merit Selection Commission. As a result of the layers of merit-based review, the Commission then decides which candidates are qualified and which are not. Finally, the Commission nominates 3 individuals to be considered by the General Assembly for the particular position. The person receiving a majority of the votes of the members of the General Assembly is ultimately elected judge. And this same procedure is followed for the selection of family court judges, circuit court judges, and both appellate courts. The selection process is nonpartisan in nature, and there's absolutely no fundraising involved. I think the only cost I incurred during my last election to the Supreme Court was less than $100 for postage. This is a far cry from the millions of dollars being raised by Supreme Court candidates in states that have public election. As I said earlier, ours is not a perfect method of electing judges, if indeed any perfect system exists. Whenever human beings are involved in a process, there's always room for considerations which may not be based completely on merit, and regrettably, there's room for prejudices and parochialism. Any method of judicial selection involves politics in some form. One criticism which has been lodged against our system is that it produces less female judges and fewer judges of color. While that may have been true in the past, it seems to be increasingly less true. When I was first elected to the family court bench in 1986, I joined only 2 other women judges in our state court system, and there were only a handful of African American judges at that time as well. Now, however, the percentage of women judges is approaching the percentage of women members of the South Carolina Bar, and the percentage of African American judges is more than double the percentage of African American bar members. Until this year, perhaps the single greatest moment for women in the state judiciary was that day in June of 1999 when Jean Toll and I were elected by the General Assembly to lead the 2 highest courts of this state. It's the only state that that's ever happened in, that 2 women were elected on the same day to be Chief Justice of the Supreme Court and Chief Judge of the Court of Appeals. This year, on the same day in February, 3 women were elected to the Circuit Court bench. And I understand that in a few weeks, the General Assembly is poised to add 2 more women to the Family Court bench. I do believe that our selection system here in South Carolina has produced a cadre of wonderful, hard-working judges. Even though the work of the courts has been increasing greatly over the last decade, the South Carolina General Assembly has not created any new judicial positions for well over 10 years. The caseload of our trial judges is the highest in the nation. Moreover, despite the increased caseload, our Chief Justice is receiving $10 million less in state appropriations to run the Judicial Department than she received when she became Chief Justice in 2000. Even though special interest groups continue to try to influence the results of judicial elections, I believe we have in this state a judiciary which is both independent and impartial. Instead of judges who must consider the public's reaction to a given decision in order to ensure their continued employment. We have judges who have the freedom to follow the rule of law, to dispense justice as the goddess herself would, blindly, without regard to the identities, the wealth, or the political cachet of the litigants. In my view, we should do all we can to preserve our merit-based system of judicial selection and resist a process whereby the public chooses judges based upon their political persuasion or the popularity of their decisions. The reason for that is because what is right is not always popular, and what is popular is not always right. I am proud to be a state court judge in South Carolina. In my work with the Council of Chief Judges, which is a nationwide network of chief judges, I quickly came to realize that our system of selecting judges produces judges free from the political trappings which accompany popular election of judges. I hope this program today will shine more light on our judicial selection process and will serve to not only give you a better understanding of our judiciary here in South Carolina, but also engender in you a sense of pride in our system. Thank you so much.
Good afternoon, and I also thank Lee for we have different problems, Justice Horry.
And you should see us when
we go shopping together. It's very funny. We try on the same clothes, and it's quite a different appearance. We went in one shop one time, and they said, "Wouldn't you two like to try on shoes?" Well, she's a 4, and I'm a 12, so they couldn't accommodate either one of us. I'm really not going to take too much time, but what I'm here to talk to you about is I would concur with Justice Hearn on the excellent way I think that we elect judges in South Carolina, and you only have to look at other states and some of the problems that they have to realize how good our system is. And because of that, being in a position where I'm responsible for the regulation of judges and lawyers and how they behave in our state, the good news is, and I should just say this and sit back down, we have no problems with our state judges, just about. South Carolina is one state that does self-regulate both the practice of law with our lawyers and the judiciary. And that's done through the Supreme Court. You'll find some states, for example, that regulate lawyers through their bar, but we do it through the Supreme Court, which I agree with. And that is done through the Office of Disciplinary Counsel, and we'll just speak about judges, and the Commission on Judicial Conduct. And it's important to know that because when the process takes place, it is not just one person looking at a judge and whether or not the judge has violated any of the conduct for which they have committed to uphold. All judges except the administrative law judges are under the jurisdiction of the Office of Disciplinary Counsel. And administrative law judges are part of the executive branch and they go through state ethics, so that's a little bit different. But we have from the municipal judges, magistrates, and all of the family court, probate court, master and equity, and our circuit and appellate court judges, any complaints that are lodged against any of these judges come to the Commission on Judicial Conduct and the Office of Disciplinary Counsel. In order to start that process, there must be a complaint. And if somebody were to call us and say, I know this judge, it's in Darlington County, and he just never does anything right, or she never does anything right. Unless we actually get a formal complaint in writing, we're not going to do anything about it. We're not out looking for misconduct. We're there to work with our profession and uphold the integrity of the judicial profession. So when we do get a complaint, the process is really very simple. The complaint comes into the commission and it's sent over to the disciplinary council. We are made up of 9 lawyers, 2 investigators, and administrative staff. and we take a look at that complaint and say, do we even have jurisdiction? Is there an allegation of misconduct? And if there is not, and we get plenty of letters from, we might get letters from inmates saying, you know, the judge gave me 35 years and everybody else on my wing only got 12. There must be something wrong with the judge. And we will send a letter back and, you know, basically say we don't have jurisdiction on this type of matter. But if there is, and the standard is, if the allegation of misconduct were to be, or if the allegation in the complaint were to be true, would it be misconduct, or in the case of judges, a violation of the canons of judicial conduct? And if the answer to that question is yes, we then send a copy of the complaint to the judge and say, we have received this complaint and you have 15 days to respond to us. And that begins the investigation. The Office of Disciplinary Counsel does the investigation, and the only disposition that we can perform is to dismiss something. Anything else, a panel of eyes are put on it, and we will bring that complaint and any investigating we've done and the response from the judge to a panel of the Commission on Judicial Conduct. And I think what's important to know about that panel is it's made up of judges from each category: magistrate judges, municipal judges, probate, master, circuit court, family court. There are also lawyers on the panel, and we have, for every panel reviewing these complaints and investigations, 2 lay members, 2 members of the public that sit in on these decisions as to whether there in fact has been misconduct. The rules of professional conduct for lawyers are very specific. You may do this, you may not do that. The canons are, as we refer to them, sort of aspirational. In other words, there are only 5 canons, and they relate to the integrity and the independence of the judiciary, the impartiality, independence, and within those canons there are some comments that are a little bit more specific, but basically that's what we're looking for, is to look at the behavior that's reported to us as to whether in fact that is going to affect the independence or the impartiality of the judge that's being complained against. We also, in South Carolina, interestingly, there is no requirement to self-report misconduct until this year, and that's changed a little bit. And if a judge, who, by the way, is also a lawyer and can, in fact, fall under the rules of conduct for a lawyer, if you are arrested and charged with a serious crime, you must now self-report, and that's new as of 6 months ago, actually. Up till then, there was no requirement for self-report. Where do the complaints come from? They come from litigants, primarily. They come from lawyers complaining about a judge. They come from one judge reporting another judge. They come from concerned citizens that have been sitting in court, could be a juror, and any source, as long as they identify themselves as actually filing a complaint. The system is confidential in that, and we are the ones that are bound by the confidentiality. If a judge has had a complaint filed against them, they may talk about it, and the complainant may talk about it. But if you were to call our office, for example, and say, you know, I've got a hearing in family court, and I understand it's in front of Judge Madison, has that judge ever had any complaints filed against them? The only thing we could possibly tell you is whether there was any public discipline that was issued against that judge. We can't tell you whether there have been any other complaints. We can't tell you whether there's any pending complaints, and we can't tell you whether there have been complaints that have been resolved with either a dismissal, or we have one other private resolution, which is called a letter of caution. And we will issue letters of caution to judges that say, you know, this was not misconduct, but, you know, you might want to read the rules again. You might want to take a look at the canons and be a little bit more careful. And those are considered to be confidential. I thought I would just give you some statistics, and then I'll tell you the particularly good news for our circuit, family, and appellate court judges. Last year, we received 317 judicial complaints. In comparison, we received 1,650 lawyer complaints. Now, there are a lot more lawyers, of course, than there are judges, but you can see that 317 is not a large number. Of the 300, and we had 53 pending, of the 334 complaints that were resolved last year, 85% of them, or 285 of them, were dismissed. Generally speaking, if somebody is not happy with the outcome of their case, they're going to complain about the judge. We get a lot of complaints, both of lawyers and judges, from family court. And I think that's just the product of the fact that many people leave family court very unhappy for one reason or another, and so they will complain about their lawyer, the other party's lawyer, or the judge, and somehow it'll be somebody's fault that the visitation did not come out as they anticipated. So 85% are dismissed. Only 6% receive a public sanction. And when we refer to a public sanction, or any sanction, we have an admonition, and that can be confidential. That can be issued by the commission in a confidential manner, but it is in fact a sanction, and it would be reportable, for example, to judicial screening. We have a public reprimand, and that would result in an opinion, a published opinion. We have suspensions. We can suspend judges. And then we have removal, and a judge can be removed. What is, let me tell you how many complaints have come against various types of judges. We had in that, in that given year, 2 complaints against judicial candidates, 8 against members of the appellate court, 9 against masters, 19 against the probate court, 37 against municipal court, 55 for family court, 69 for circuit court, and 118 for our magistrates. The result, however, is that as far back as anybody in our office can remember, we have not had a public published opinion on an appellate court judge, on a circuit court judge, on a family court judge, on a probate judge. They have all been on our magistrate judges and municipal judges, and one that we can recall, a master in equity. I think that speaks to a couple of things. Number one, I think we're doing a really, really good job of electing our judges. I think the screening process is good. There are a lot of people that take a look at our candidates for our judiciary, and they are doing an excellent job. It does not mean that the magistrates are not doing a good job. They are the first line. They are the place where everybody goes for the first time. If it's a criminal charge, that's where they have their bond hearing, their preliminary hearing. Our civil cases, many of our civil cases are held before magistrates. Another thing that is very unique about our magistrates, they are the only level of judges, magistrates and municipal judges, they are the only level of judges that have to deal with money. Nobody else has, any of our other judges don't have money as part of the process. They have magistrates' funds, and many of the issues that have come up that have resulted in public dispositions have had to do with not doing proper record keeping. It's not misappropriation. It's generally just not following the Chief Justice's order for record keeping of the funds. They get a lot of money that comes into their office. They have various disbursements, and so that's what we see with our magistrates. We have a lot more cases of what we refer to as ex parte communications, where one party speaks to a judge without the other party being aware of it. We don't see that with our family court judges, circuit court judges, and certainly not our appellate court judges. So I think that it's not a matter of them not doing their job. It's just a matter of numbers, and we have this with the financial thing. I looked at last year the public opinions. The good news is I can't share any public opinions with you on our circuit court, family court, or appellate court judges because we just don't have any, and that is consistent, but we're very much ahead of the game when we look at other states, and a lot of that has to do with the addition of money for theirs. But of the public opinions that came out on primarily our magistrates, last year there were only 5, and one magistrate was actually arrested and charged with larceny from, of all things, taking a yard statue out of his former wife's yard. And if he learned anything, it was don't mess with your former wife's yard art.